Chapter 19 of NAFTA was first actually adopted in 1988 in the Canada-US Free Trade Agreement. And it was designed to deal with the problem that Canada, in that negotiation with the US, had wanted to be completely exempted from US anti-dumping and anti-subsidy laws. The United States finally refused, absolutely, and so it was left up to the lawyers to find a legal solution to what is essentially a political and an economic question. The way Chapter 19 works is that if there is dissatisfaction with an administrative decision on a matter of anti-dumping law or countervailing duty laws, it can be appealed. It's a kind of safety valve to ensure that anti-dumping and safe countervailing duty laws are applied fairly and in a non-discriminatory manner in which does not favor the local interest in the state involved. To give an example, recently the United States International Trade Administration has announced the adoption of preliminary first countervailing duties, alleging a subsidy, and subsequently anti-dumping duties on the production and sale of Bombardier C-Series aircraft in the United States. If Bombardier is dissatisfied with that, under Chapter 19, it can ask for the convening of a binational panel, which will review the decision and, if they think it necessary, return it to the International Trade Commission for it to take a decision more in line with US domestic law. On the other hand, you can say that the rules adopted and applied by either US administrators or Canadian or Mexican are all based on the rules of the WTO agreements on countervailing duties and on anti-dumping measures. And it is possible to raise egregious decisions before the WTO. So it's not as though we are entirely without a remedy. We can go to the WTO, and we have, in fact, and the United States has used it against us, and we've used it against the United States. So we've used in our major disputes, such as softwood lumber, both countries have used a mix of Chapter 19 and WTO. If we had to give it up, we'd at least have the WTO to fall back on. On the other hand, when you think of cases like the Bombardier case, it's clearly a very useful procedure. It's served Canada well in the past. In fact, go back 10, 15 years, there were a whole series of major cases, not only softwood lumber, but on various agricultural commodities, where the Canadian government and Canadian exporters to the United States fought very hard and used this Chapter 19 procedure with considerable success. So I think if the Canadian government, as a last resort, had to give this up in order to get other things in a renewed NAFTA, they'd be very sorry to see it go.